State of Kansas versus Tremaine J. Robinson. Jared Regier, Assistant County Attorney appearing for the state. Mr. Robinson, are you here?
I am here representing the name.
And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction. Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
Now, this is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime.
Welcome back, everyone. Today, we're dropping into Kansas, where the courtroom drama is real, raw, and utterly unforgettable. Right from the start, we meet Tremaine J. Robinson, a self-declared sovereign citizen who believes the law somehow doesn't apply to him. Across the room, we have Judge Webster, a no-nonsense jurist, and a prosecutor who won't blink in the face of nonsense. What happens when internet legal theories collide with real courtroom procedure? That's what we're about to see. Buckle up, because you're about to witness a legal showdown that is equal parts mind-boggling and jaw-dropping.
Well, the victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas, but this is not the type of crime which would require or have individual names listed. So your next point, if any?
My next point is, as I said, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with 2 signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. So again, Mr. Regier, are you ready to proceed?
I am, Your Honor. As a preliminary matter, it would appear that while Mr. Pate was still involved with this case, but before the motion in order to withdraw was filed by counsel in August, the defendant did file a piece of correspondence of some kind. It does appear to include a motion for discovery. However, that particular document would appear to be procedurally deficient. It does not appear to include a certificate of service. The only address listed appeared to be on page 1 involving the defendant, the traffic court clerk at an address both in El Dorado and in Topeka, as well as the office of the Attorney General. Certainly no service on my office, so there is that.
Now, watch closely as Mr. Robinson attempts his first big move, claiming a special appearance to challenge jurisdiction. Here's the catch. Only licensed attorneys can make these arguments. So while he's sprinkling in legal buzzwords he found online, the judge is already 2 steps ahead. This is a classic example of a legal theory meeting courtroom reality. It's fascinating because you can see the tension build. He's trying to assert control, but the structure of the law won't bend for anyone's creative interpretation. It's a real-time lesson in why procedure matters.
Subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the Defendant is referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles under the following case law. I request case 2023 TR 1193 be dismissed. Talking about municipal court, administrative law in the next paragraph, ministerial offices being incompetent to receive grants of judicial power from legislature, citing a case, looks like 140 California 1, stating that once jurisdiction is challenged, the court cannot proceed. Next paragraph, the law requires proof of jurisdiction to appear. Talking again about an administrative agency and tribunals, judicial tribunals. Alleged personal jurisdiction of the defendant is void. The court has no jurisdiction, no discretion to ignore what is alleged to be lack of jurisdiction. And then it is signed by a signature that I'm not sure I can make it out, but it says Robinson-Tremaine, comma.
Next, Robinson tries the I didn't hurt anyone angle. This is a moment where common sense clashes with legal principle. Just because a speeding ticket doesn't injure someone physically doesn't mean the law doesn't apply. The courtroom response here is subtle but firm. The judge explains that laws aren't just reactive, they're preventative. Speed limits exist to prevent potential disasters, and claiming a victimless crime doesn't erase the statute. For viewers, this is a critical teaching moment. Intent and impact are different, and ignoring rules doesn't remove accountability.
Which talks about a legislative act of constitutionality, substantial harm, right to a trial by jury, all power inherent in the people, legislative assembly. Officer Collins K. issued the ticket summons on the side of the road and did so without an affidavit of complaint approved by the clerk of the court or judge. Quote, I request a certified copy of that complaint from my accuser stating who it injured. Continuing, quote, no bill of attainder or ex post facto law or law impairing the obligation of contract shall ever be passed, end quote. Then he goes on to request this Officer Collins, quote, speed detection device, including model and serial number and year installed, any documents pertaining to the training certification, disciplinary reports of the trooper, tuning fork calibration records, certification records for the device, more information about calibration records, device records. He says the information requested directly relates to reliability and accuracy of evidence against him. So he's wanting proof provided within 21 days, or an immediate dismissal based on Rule 12, which comes from the Federal Rules of Civil Procedure under 28 USC 1746, Section 1. And then it is signed declaring or certifying or verifying or stating under penalty of perjury under the laws of the United States of America, executed July 26, 2023. Again, signature, and then in brackets, Robinson, Tremaine, J, without prejudice. Pretty much the same things he's gone over before. Talking about the judicial officer has to cease because of the administrative law, and pretty much standard language that is used by folks who call themselves or are
Hold on to your seats. This is where it gets really entertaining. The defendant submitted a 7-page packet full of every sovereign citizen theory imaginable: gold fringe flags, admiralty law, right to travel, and more. Courts have seen these tricks before, and they're remarkably consistent in how they respond. Calmly, methodically, and with zero amusement. This isn't just a quirky legal battle. It's almost theatrical. For anyone new to sovereign citizen tactics, this is a perfect example of why courts treat these filings as procedural curiosities rather than legitimate legal arguments.
Quote, it is on this date, July 27, 23, I, Tremaine J. Robinson, it's Tremaine-J, Robinson, in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, as a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and/or agreements signed by the side of the road in the state of Kansas by Officer Collins K., March 27, 23, and then signature authorized representative and attorney in fact. So after that document was filed pro se, apparently by the defendant, Mr. Pate filed a motion to withdraw due to the defendant wanting to proceed pro se. And that was authorized based on the previously referred to 7-page document. It would indicate at the time to the court that Mr. Robinson did want to proceed pro se. So Mr. Pate, attorney, was allowed to withdraw. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk, Traffic Court, Butler County District Court Traffic Court. You sent one to a P.O. box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler attorney.
Okay, well, that's not on file. What you want to present that at this time?
Now we see the core of the procedural problem. Robinson requests affidavits, calibration records, certifications, and expects all of it instantly. The courtroom's reaction is telling. The system operates with rules, timelines, and deadlines, none of which bend to internet-inspired legal fantasies. The beauty of this scene is watching the contrast. A defendant expecting magic versus a court executing procedure with precision. For viewers, it's a reminder. Knowledge of the law and adherence to process outweigh theatrics every single time. No shortcuts exist in real courtrooms.
That I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant that I'm giving the benefit of including what he offers as a motion for discovery was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable. And I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last minute motion for discovery is denied and we are prepared to go to trial. Now I've lost you, Mr. Robinson. Are you still somewhere available?
No.
What are you doing there with your computer?
Right now, I was looking for a document, but no, I am not available for trial.
So please put yourself back in front of the camera. Follow the court's order, or you could be found in contempt. I don't want to do that. Thank you, sir. All right, Mr. Regier, did you tell me you did or did not have any opening argument or opening statements?
Your Honor, I did not specify one way or the other, but the state would waive opening statements at this time. However, if the state would respectfully request leave the court to read from some Kansas case law put down by the Kansas Court of Appeals, which does appear relevant in this matter.
All right, you can document those for the record.
Yes, Your Honor. The state would now respectfully read from State v. Mayor. It's a Kansas Court of Appeals case, 466 P3D 1236.
Go ahead.
Your Honor, in that particular case, involved a sovereign citizen, where the court noted in the memorandum opinion.
Objection, hearsay. Objection, hearsay.
Case law is not considered hearsay or.
Judge Webster's reaction here is priceless. She doesn't overreact, doesn't need to raise her voice. Her body language says it all. Unimpressed, unmoved, and utterly uninterested. She has seen it all before. This isn't the first time a sovereign citizen has tried this script, and it won't be the last. For the audience, take note. A courtroom isn't a stage for theatrics. Judges are trained to see through attempts to game the system. And here, you can literally see that expertise in action.
He's not a sovereign citizen. Go ahead, Mr. Regier.
Yes, Your Honor. In that case, the Kansas Court of Appeals noted, quote, the defendant thinks the law does not apply to him. He avows that he, unlike other citizens, is sovereign and immune from prosecution. The court went on to address the issue of venue, which the court noted that, quote, venue is generally proper in the county where the crime was committed. I will address that momentarily, as well as referring to KSA 22-2602. Additionally, and perhaps most relevant to this court, the defendant in that case, quote, complains that his objections to the trial court's jurisdiction to prosecute him arise from the claim that he is a sovereign citizen. This is not the first appellate court to deal with such a claim. Another panel of this court used analysis of federal case law to reject a similar claim. And then quoting from Seventh Circuit and Eighth Circuit cases, quote, an individual's belief that his status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law. Regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being, that person is not beyond the jurisdiction of the courts. These theories should be rejected summarily, however they are presented. In referring to an Eighth Circuit Court of Appeals case, United States v. Yagam from 1992, Yagam found similar issues were completely without merit and patently frivolous. It rejected those issues without expending any more of these courts' resources on their discussion. And again, the Supreme Court also referred to a Kansas Supreme Court case from 2019. Quote, our Kansas Supreme Court has recently affirmed the Requena panel. The court held that the claims of sovereign citizenship are ultimately meritless. Thus, if the defendant's arguments are on appeal, rely on his sovereignship claims, we hold they are meritless. And with that, I would respectfully call my first witness to the stand.
All right. I do find that this court has jurisdiction and venue to proceed, and the arguments made by the defendant in the 7-page document referred to previously are summarily discussed.
And here comes a reality check. Robinson served his motion for discovery just yesterday and expected immediate results. That's not how courts work. Deadlines exist for a reason, and procedural rules are enforced to maintain order and fairness. Watching this, it's hard not to cringe a little. Expecting instant compliance with a 7-page document filed out of order is wishful thinking at best. The takeaway? Understanding process is just as important as understanding law itself. Miss deadlines or ignore procedure, and even the most creative legal theory falls.
A citation for speeding?
Yes, I did.
or an annual redirect, no further questions.
All right, Mr. Robinson, this is your opportunity to cross-examine the trooper. You can question him about his testimony. It's not quite time for you to give your own testimony, so these addresses to the trooper have to be in the form of question. You don't have to question him, but you can. Would you like to? Mr. Regier, any further evidence?
None from the state, Your Honor.
The state rests then, Mr. Regier?
The state does so rest, Your Honor.
Mr. Robinson, the state rests. They have presented all the evidence they intend to. Would you like to present any evidence? Again, you don't have to. Your silence will not be used as a sign of guilt. But if you'd like the court to consider your position, I'd be happy to do so.
I don't understand.
Well, do you want to tell the court your version of what happened?
No.
All right. You don't wish to present any evidence then. Am I understanding you correctly? But do you want to give any testimony about the events leading up to this ticket, March 27, 2023?
No.
All right. Well, I will find the defendant guilty of speeding 92 and a 75. The scheduled fine is $87. Court costs are $108. The total due will be $195. Sir, you do have the right to appeal this proceeding. You can appeal it to the Kansas Court of Appeals. You have up to 14 days to file that notice of appeal. Your appeal bond will be in cash, the same as what your court costs and fines are. That's $195. Can you have this paid, this fine and cost paid in 14 days, or do you need some time?
So, what did we witness in this Kansas courtroom? A clash between unorthodox legal theories and real-world procedure. Judge Webster handled it with calm authority, and the law spoke louder than buzzwords or pseudo-legal jargon. Robinson's filing? Entertaining, but ultimately ineffective. This case reminds us that in court, knowledge, preparation, and procedure are everything. If you found this showdown as shocking and fascinating as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping breakdowns.